All rise. The Court of Appeals Division 1 is now in session.
Thank you, folks. Have a seat. All right, good morning. Welcome. I don't see any masks, so I think we can dispense with that. We're here for oral argument in 1 CACV 220427, Joshua Tree et al. V. State et al. As you may know, we do live stream and record these arguments, so we do ask that you state your name and state your client's name when you begin your argument so that we have for the record who you're appearing for. You are going to argue from the podium. We have abandoned the COVID protocol at this point. You'll have a maximum of 20 minutes per side. You are not required to use the entire 20 minutes. We do require that you keep track of your own time, so counsel, if you wish to reserve time for any rebuttal, you need to do that on your own. The clock on the podium does count down, not up, so it is your time remaining, not how long you've been talking. What I would ask is that we have conferenced this beforehand. We have read the briefs carefully. We have talked this over, so we have a very good understanding of the case. We'd ask you to focus your arguments for us today on what you believe are critical things for us to understand. And with that, counsel, you may proceed.
Good morning, Your Honors. My name is Ross Meyer. On behalf of appellants, this is Mr. Mason Cave, who's the manager of the appellant entities. So this case turns on when is the department required to accept applications for medical marijuana dispensaries. What the department argues is they're able to review the dispensaries in the state every year, and then after that review, determine whether they're able to open an application period or not. And they base that on 362803, saying that they're permitted to adopt rules and impose those rules. The problem with that argument is that the statutes allow them to adopt rules governing the form and content of those applications, but not necessarily when they accept those applications. The applications have to be accepted when there is a county that is without a dispensary, or when the number of pharmacies in the state exceed the 1 in 10 ratio.
Counsel, don't they have broader rulemaking authority under the department's general rulemaking authority to address all provisions of the statutes involved in the AMA, not just the one on which your client focuses?
Of course, a department has general rulemaking authority, but they're still limited by what the statutes expressly state. And if the statute expressly states that they're able to adopt rules related to the form and content of the applications, that doesn't mean they can then go outside of that form and content just because of general broad rulemaking authority.
Where is there in the statute that we find that was intended as an absolute restriction? Because that's what your client is arguing.
Yes.
It's an absolute restriction.
It's an absolute restriction, and here it's for at least two reasons. I may think of a third. But first, there's the difference between the the registration cards for people who have a medical condition. Under that, it's broad and states that they can establish the manner. And so that's a key, govern the manner in which they consider applications. That's very broad, but then when it's talking about the dispensary registration certificates, it says they can only establish the form and content. That's not governing. It's different language, and so that's one key component. The second key component is that where you do get this language relating that's similar to the identification cards is under Section 4, but to get there for the dispensary registration certificates, that rule has to protect in some way against diversion and theft. And so that's the first statutory basis. And I have one more, which is under 362804C, which indicates that they have to accept applications based on soil healing when a county is empty or when the 1 in 10 ratio is exceeded.
Well, in fact, the footnote in soil healing says annually. It doesn't say whenever. It actually specifically says annually.
Correct, and that in soil healing, there wasn't the challenge of when applications were accepted. It was the number of certificates that would be awarded. So yes, the soil healing court does say that, but it didn't take up this issue about when the department must accept applications.
So is it your position then that soil healing's footnote solely was based on, the annual was solely based on Rule 303?
Yes, and it was not based on any statutory interpretation.
Is it your argument, and I just want to be clear, if 303 doesn't fall, can you prevail?
In the event there's a determination that the department must accept applications outside of an application window when a county is without a dispensary registration certificate or the 1 in 10 ratio is exceeded, yes.
How do we do that with 303F? Because I don't see in your briefing at all an explanation why 303F falls.
And so which part about 303F?
303F is the provision that says the department will reject any application that's filed outside the application period.
Right, and so how I would interpret that is that the application period would be when there's not an open county or when the 1 in 10 ratio is not exceeded. That under those circumstances, of course the department should reject.
And again, then I come back to 303 has to fall in its entirety for you to prevail.
I believe it should. I don't believe the department has the statutory authority to establish the rule of 303 in so far as when it accepts applications, because the statutory authority indicates that if there's an open county or the 1 in 10 ratio is exceeded, they must accept applications. Otherwise, what happens is what's happened the past decade under AMA. When in 2012, that was the first allocation after it was passed and opened. An application period didn't open until 2016, which only opened because of settlement of a lawsuit. And then an application period didn't open for another 6 years until this past December, which again was the result of a settlement of a lawsuit.
And so let me, if I can, what you're talking about though is inconsistent with what 303 requires, right? I mean, what you're talking about is like an Olympiad, a 4-year or 5-year period as opposed to annual review.
Correct.
But to follow up and to ask it from a somewhat different perspective, you are asking us to strike 303 as sort of ultra-virus, which is a pretty big ask. I mean, but what I need to know is whether we need to address that. And to rephrase the question, if 303 applies, is that a concession that your position fails? If 303 is properly promulgated and consistent with the statute, can you prevail? Because in other words, I'm trying to figure out whether we need to address the validity of 303, and only if you would fail in that environment would that issue be squarely presented.
I think 303 does fail, and
I understand that.
Yeah,
but my question is what work we need to do to work through the case.
I think what I would recommend this court do is to indicate that the department is required to accept applications when there's an open county or the ratio is exceeded, and then 303 and the components of it could still apply in some meaningful manner in the sense that the department's made aware of an open county, let's say.
Help me better understand that, though, because you're saying 303 is inconsistent with the statutory framework, but now I hear you saying, well, maybe 303 can live.
Some parts. So, for example, the department's made aware, and this is easy to do because to move a dispensary license, the department's notified. At that point, the department says, okay, we're going to accept applications in 30 days. For this county. And then the 90-day statutory period in which they must process that application would apply. And so I think in that framework, it's a trigger, but they can't wait I think that's agreed upon, that they can't know there's an empty county and then wait for a court to tell them to open an application period.
And I understand that, although 303 has this annual review thing that if followed, it wouldn't involve, if followed, and I understand it sort of wasn't here, but would have every 12 months. Let me ask you another even more basic question. The state argues that you waived this challenge to 303. Help me understand where you raised it in Superior Court.
Yeah, and so the basis of that waiver is that the statement of facts, we did a joint statement of facts, it indicates that the department must follow its rules. And so that statement of fact is then used to say, well, the rules are valid and the appellants have agreed that the department must follow these rules. That's fine, of course. We all agree the department must follow its rules. That doesn't mean they did follow the rules, and that doesn't mean that the statutory basis for those rules, for that specific rule, was properly interpreted. And so that's the argument.
And I guess what I'm looking for is what filing in Superior Court did you make, or on behalf of your clients, saying 303 is invalid?
The reply, I believe it's talked about in the initial motion for summary judgment, but it's heavily addressed in the reply brief.
Help me where it's raised in the initial motion, because if we're talking about being raised in the reply, that's maybe too late in the judicial.
I'll double check and get that for you, but I know it's very detailed into in the reply brief, but I'll find it in the opening brief. But I don't think that was the issue raised in the answering brief. It wasn't that it wasn't addressed in the opening brief, or I'm sorry, the original motion for summary judgment. The argument was that this statement of fact was agreed to, and so therefore it's waived.
And I understand that, and I appreciate the party's view on what stipulations mean, and what I'm looking to do is to go a bit beyond that. And if you can provide clarification and rebuttal, that'd be great.
Of course, I will. And
Can I jump in here before you move on?
Yes.
Because what I heard was something important to me. You seem to concede that the department, for example, if it learns of an empty county, can put out a notice and wait 30 days to accept applications. Would your client concede that they can do that under the statutory rubric?
I don't think we would concede that and say that's based in a statutory rule, especially under 2803, 2, and 4. But I can see that it would provide a process of notification, because there's not some
But your
requirement.
argument is they can't do that.
I don't think they can. And so there's not a statutory basis to say we have to provide notice to the general public that we're accepting applications.
Your client's position is as soon as anybody sends in an application, the application process is open.
Exactly, if there is an open county.
Now, when you say that, if there's an open county, is it the department's job to go check and say, hey, yeah, I guess there is, or hey, and because I'm going to use the 1 in 10, because the 1 in 10 or 1 to 10 ratio also would apply. All right, let's go look and do the math today and see if there's 1 in 10. And someone submits tomorrow, we're going to go look again tomorrow and see if there's a 1 in 10. Isn't that what you're asking the department to do?
Yes, but I would like to make a couple of things clear. One, that issue wasn't raised at the lower court as some type of defense from the department, in the sense that this...
No, but I just want to understand what the department would have to do.
Yes, the
I'm
department would...
suggesting it's defense. I want to see what happens if we follow your rolling application.
Yep, so the department would have notification from the pharmacy board and know those numbers. They're public numbers as to how many pharmacies are in the state, and be able to make that determination. Also, the department would receive notice and know whether or not there's an empty county. And so what the department could do to...
Wouldn't your process allow for potential diversion? I mean, and because different dispensaries could share information about when they're planning on closing, so that a preferred dispensary from their perspective can jump in the moment they close, and other people are excluded, and defeat the purpose of the statute, defeat any public notice.
So there's two things about that. One, public notice isn't some part of the statute. The key part of the statute is that dispensaries will be accessible to everyone in Arizona for these medical conditions. The rules in 303 attempts to prohibit that by limiting it to only once per year and other mechanisms. But secondly, as part of the notice, the department could, once it receives that indication that the 1 in 10 or the counties are available, could publish on their website. It doesn't have to be a requirement to accept applications that they have to publish, but they could post on their website and say, look, there's open dispensary certificate in Santa Cruz County, and then provide that notice. But it's not a component of when they accept applications based on the statutory mechanism. And so I think that's one of the key parts. And then where I want to get to is what would happen. And the department's raised this issue in the sense that in 2016 there were over 700 applicants, and this would create chaos. And I think that's entirely incorrect. And the way you can see this, and it's not apples to apples, but is initially the card holders for individuals can apply anytime. And initially there were a lot of card holders, and they still do that. There's a rolling basis of that. And the department isn't saying we can't handle this, we need to open an application period window for card holders. If the department had done their job and reviewed it every year, there wouldn't be this mad rush, because we'd have full counties every year. We'd have the 1 in 10 ratio met every year, but instead the department waits, and so they're the ones creating this chaos that they allege would happen. But I also don't think it would happen, because we just had an application period for 6 empty counties.
Let me interrupt for a second, Council, which is all of the history really is not before us. What's before us is whether or not these rules can stand. Even if they had been doing everything the way they're supposed to, your client may not have sued, but you're saying these rules still need to follow even if they follow the annual provision. So I want to make sure I'm correct on that, because I don't think any of that history matters.
That's fine. I was making a point as to the chaos is not at issue, because what's at issue is the department must follow the statutes. And if their rules exceed their statutory authority, then that rule has to be stricken and rewritten in compliance with this court's decision.
Mr. Meyer, I know your time's going fast, but no, please don't sit down yet. I want to hear your response to the argument that the mandamus relief that you're seeking in this case is not warranted, regardless of.
Yeah. So the mandamus relief is not that the department evaluate the application, issue a dispensary registration certificate. It's that they accept the application, and that is a procedural component. It doesn't have any decision making associated with it. There's an open county. There's an application submitted for the open county. We will take this, and then we will review it within our process and our outlined statutory authority.
And so from your perspective, there's no discretion involved in that?
No, it's here's the application, and then the department, once it accepts it, then it processes the application and determines if it contains all of the statutory items, and so no.
So the filing clerk receives it, and whether it's righteous or not is something that's decided.
That is a secondary item.
So could they review it on an annual basis after they've accepted them all? If it's just an acceptance, here it is, and now we've got an annual review process for all the ones we've accepted during this time.
No, because 2804B requires that they process it within 90 days of acceptance of the application.
Okay.
Okay, I'm going to reserve the remainder of my time. Appreciate it.
Thank you, Counsel.
Good morning, Your Honors. I am Gregory Falls with the Sherman & Howard Law Firm, and with me at council table is Matt Hesketh, who was also on the briefs with me. We are representing the state of Arizona, the Department of Health Services, and Jenny Kunico in her capacity as interim director of the Department of Health Services. There are two rulemaking authorities at issue here. One, Judge Goss pointed out, is ARS 36-136. That's a general rulemaking authority that the department has to make rules governing or relating to the health of Arizonans. That applies here. There's also rulemaking under the Medical Marijuana Act, which is 36-2803. Now, 36-2803 says you shall make these rules. So there are some rules that the voters said, we want to make sure that you make these rules. But no place in 2803 did the voters say, you shall not make any others. And in fact, it would be absurd to think that the voters knew when they were voting on this law every single rule that may be necessary to administer a very complicated program.
So, Council, we just heard a presentation from Mr. Meyer that the statute itself says it can only make rules with regard to diversion, and are you saying that only is not in there?
Reading from it, the statute says the department shall adopt rules, and this is 2803A4, governing nonprofit medical marijuana dispensaries to protect against diversion and theft without imposing an undue burden, et cetera, et cetera. The word only is not there, but what is there is the word including. And including, as we know, means that you will do these rules, but you may do other rules. Now, I want to jump to the diversion and theft issue, because if you think about it, it does refer to the manner in which the department shall accept applications. Well, there is nothing to divert or steal in the application process. We start with a blank slate. You have what is usually a newly formed company that wants a dispensary registration certificate. Originally they filed in paper, now it all happens online. But what they do is they fill out some paperwork, they submit it to the department, they say, we want a certificate. The department analyzes that. This is in Title 41, for all licensees, but also applies here, and that is there's an administrative review, which is everything that's supposed to be here? If it is, then you move on to substantive review, which is more detailed, and that detailed review says, okay, do you get, have you met all the requirements to qualify for this? If so, then we will move on to the priority allocation. Now, the priority allocation is significant because if you look at the facts of this case, each one of these plaintiffs filed an application in a separate county, and according to the facts of this case, they were the only party filing on that date at that time in that county. And as counsel said right before he sat down, there is an obligation to process these within 90 days. That's in AMA. That also is in Title 41. And in fact, if the department does not process them within 90 days, there are penalties, monetary penalties, and other things that would be assessed on the department. So you picture, we had only one applicant, but you picture two applicants. One of them files on a Monday by dropping it in the mail. The other hand delivers it on a Tuesday, and the one dropped in the mail on Monday shows up on Wednesday. Who gets priority? There is no priority first to file. There's nothing like that. The priority, which, by the way, was significantly addressed by the legislature in 2019, is a very complicated process where you look at all of the applicants and you consider where are they located, where are the patients, and based on a formula, you determine which applicant is most qualified and receives the certificate.
They're not saying that they're seeking mandamus for that, though. They're saying we just want mandamus for you to accept, your client, to accept the application.
Yes, and if you think about it, and they compared it to individual patient card holders, there's no limit on those. At one point, I think there were close to 300,000 individual patient card holders. There is a limit on dispensaries. That limit prior to the recent allocation, there were 131 dispensaries. The 110 ratio would have allowed a total of 134. So we had 3 more dispensaries that were available prior to the recent allocation. There were 6 empty counties, so all of those counties got allocated. So now we have 137 dispensaries. No empty counties, nobody else is allowed to have one on the 1-in-10 ratio. So
Absolutely.
under what set of facts, pardon me.
No, please continue.
Under what set of facts is the department required now to accept serial applications that are coming in the door every day, every week, whenever? This is an extremely complicated process. The department can process individual patient cards in 5 days and is required to do so and does so. Typically, the allocation process takes about 2-3 months approximately. At one point in 2016, there were 750 applicants, so it's not something that you just look at a piece of paper and say, okay, you're good enough. You're good to go.
I think we understand your position on,
Okay.
on that point.
Okay.
Let me ask you, with respect to 303 and the challenge, Rule 303, and the challenge to its promulgation, was it promulgated under 362803 or under 136?
I don't know.
Or both.
I don't know that there was an identification in the rulemaking that said we are adopting this under either one of those. I believe both of those authorized. 136 generally authorizes
Give
it.
136 generally. Help me, what part of 2803 do you think would authorize?
2803 authorizes rules governing the manner in which the department will consider applications, and that's 2803A4A.
Okay. The reason why I ask you about that is 4 seems to talk about governing nonprofit medical marijuana dispensaries, and then it talks about some other things. I don't know that the application process is actually governing how these things work, and that's why I wanted us to talk about that.
Yeah, I recall when this law was first passed back in 2010, a judge from Tucson by the name of Judge Fields famously said, this law needs a lot of work. The unfortunate thing is this law is protected by Prop 105
Right.
In the Constitution.
Right.
So the legislature is limited on what they can do to it.
I understand, and I just wanted to understand your position, because that 4 can be read, as this case demonstrates, a variety of different ways.
Oh no, I agree with you completely. I also agree with the comments on this case turns on Rule 303. If Rule 303 is valid, then everything that happened here was appropriate. If we throw out Rule 303, then a lot of my arguments go away, but I don't know how we would consider applications at that time.
Can I ask you, with your comment that everything was okay under 303, it strikes me that 303 wasn't complied with for a period of years, and that's what brought us to where we are today.
Yeah, and you're referring to the requirement that there be an annual analysis. As argued by the department in the Saguaro Healing case, the department viewed that the limits, the 110 ratio and the every county, as a floor. As a ceiling,
Right.
not a floor.
Right.
And there was an argument over may versus shall, and what
Understand.
does it mean?
Right. And it was the obligatory may that the Supreme Court decided, right?
That is correct. And so prior to the Supreme Court saying that, it was the department's position that we can choose when to do this, but we're not required to do it every time one is available. I think it was clear, based on the Supreme Court's ruling, that no, you shall do it whenever something is available. Now, that happened in 2020. Why did we not get an allocation until March of 2023? It was almost a perfect storm, and if you look at the context of Saguaro Healing, that was a reversal of a granting of a motion to dismiss. So the case went back, and there were some issues to litigate. Among others, Saguaro Healing believed, well, just give us a certificate, we win, thank you very much. That needed to be litigated, and in fact, the case came back here on a special action to decide where we go from there. And the order was, no, you go back and look at the 2016 applications, there were at least 3 of them, evaluate them under the process at that time, and issue to the appropriate party.
And if I recall correctly, at least 2 of the 3 members of the panel are familiar with that matter.
I believe that is correct, yes, Your Honor. That judgment was entered in late November of 2021. It became final, I think, on December 22nd or 3rd of 2021, and notice of allocation was issued the next day. That certificate was issued on December 28, 2021. So there were some issues that had to be resolved. There were 2 more issues that had to be resolved, and in part because of the left thumb case, the question was, do we allocate first under the 110 ratio, or do we allocate to empty counties first? Because as we have seen now, if you give the empty counties their certificate first, sometimes nothing is available under the 110 ratio. The judgment in that case was you allocate to the counties first and then the 110 ratio. There was one other problem. The Ducey administration was famous for its moratorium on rulemaking, and the priority scheme in the rules as they existed back in 2022 was completely inconsistent with the statutory changes made by the legislature. The department was finally successful in getting the amended rules through GERC in September of 2022, and subsequently issued the 30-day notice, followed by the 10 working days for applications to be filed, and that happened near the end of last year. So that's why it took so long. Now, in the end, the department was, according to the Supreme Court, wrong in its analysis of may versus shall, but there was no intent, and there's no evidence of any intent to engage in wrongdoing.
Well, and I understand what you're saying, and we're here, for 2 specific years that we're looking at, seeing what relief, if anything, is appropriate.
Your Honor, you asked a question about waiver.
Before you move on, I want to focus on some rule issues that I don't want to run out of time on.
Yes.
The rule changed from, for 303A, and the word shall was changed to may, conduct an annual review. I know that was dealt with somewhat in the, oh no, I'm drawing a blank on the name, you just said it.
Left thumb.
The
Left
case,
thumb?
the what? Left thumb,
Left thumb,
thank you.
uh-huh.
I'm going to do this, that way I'll remember. So the left thumb case resolved that as shall. Does your client concede that should be read as a shall as well?
Yeah, that's correct.
Okay.
I believe it was a position of the department at the time that the rulemaking, again, with the floor versus ceiling analogy, the department could make it a may. I don't think that's any longer the case.
I just wanted to make sure, be clear on it. Second issue on the rule, subsection F,
Yes.
which gives your client the ability to reject an application, refers to other than the time stated in subsection B. Subsection B doesn't refer to any time. Is that supposed to be an A? It seems to me that that's just not a correct cross-reference. And it's not been briefed on either side, but it just seems to me that it's not the right cross-reference.
I believe that is correct. The intent of F was to say, and I believe we had a footnote on this someplace in the in our brief, our answering brief. And as part of the amendments, there was an additional section added in here. And I believe that may have been something that was overlooked. The intent was, if an application is received other than during the 10-day window, that application shall be rejected. And I think again, while that issue specifically was not argued at length before the Supreme Court, I think the Supreme Court was very clear when they said, go back and look at the applications that were received within the 10-day window and give it to the one most qualified.
And it seems to me it's the only way to read that to make sense.
I would agree with you, Your Honor.
And then the last issue, the footnote in Sawau Healing that talked about the annual review. Is that based, from your perspective, was it based on a statutory read? And I'll tell you that the last provision in the statute requires an annual report to the legislature. It simply requires a listing of the number of dispensaries.
Yeah.
We're trying to sort out, I want to try and sort out, I won't say I want to try and sort out, where did that annual requirement in the footnote come from?
Yeah, the annual report to the legislature has nothing to do with the annual review for purposes of deciding whether to issue new dispensaries. I recall the Supreme Court said Rule 303 is consistent with 2804C. Now, that's different than 2803 that we're arguing here, but my interpretation of that is the Supreme Court said, based on everything in front of us today, we think Rule 303 is good, and Rule 303 at that time provided for the annual review, and so that annual review was in the rule, not in the statute. I'm not aware of anything statutory that specifically requires the annual review, but it certainly makes sense that in the scheme, you would not do a daily review as the appellants apparently want us to do, but at a minimum, you should do it annually.
A daily review, could be.
I don't know that it would be...
If it wanted to, so every day we'll double check and if there's an opening.
Yes. I mean,
That's what
theoretically, the department could do that. I don't know that that would be a good use of government resources, and I
Not
think...
suggesting it would.
And based on the number of applications, what we would be getting is multiple applications, whenever.
Counsel, can I ask a
Yes.
point of clarification? And I think you were going to address the waiver issue that we've heard a little bit about. Sawau Healing wasn't asked to address the validity of 303. It was the construction or interpretation of 303, correct?
I agree with that, yes,
Okay.
Your Honor.
Thank you.
But leading to that, on the waiver argument, you look at paragraph 12 of the Statement of Facts, and paraphrasing it, paragraph 12 of the Statement of Facts says that the department shall give notice of a time period during which it's going to accept applications, shall accept them at that time. Frankly, it was surprising that was in the briefs here an issue because we didn't think it was. So that's what happened there.
Let me ask, given that paragraph, was the validity of 303 otherwise raised from your perspective in the Superior Court?
Off the top of my head, Your Honor, no.
Okay.
Give me one moment. There was an argument made that there's some kind of a right to have a dispensary in every county. And I think by analogy, there's some kind of a right to have a dispensary under the 1:10 ratio. I think that is a right of the people. There's a right of the people to make sure that the numbers, as confirmed by the Supreme Court, apply and that the department issues those. But that is not a right of any one individual applicant who chose to file at a time when the rules in effect did not allow that. And just so we're clear, filing didn't happen. It was rejected at the filing window. But anyway, it's a right of the people, not a right of individual applicants.
So who gets to bring the lawsuit then? Are you saying that they're just not the proper party to bring it? It should have been a citizen of the county?
I think, as we saw in Left Thumb, I think that's the way you bring the lawsuit. You bring the lawsuit as a person interested in forcing the department to do its job.
That's not really before us.
Correct. And I have 13 seconds here. The Joshua Tree is moot because the county they applied in has been filled. Was filled under Saguaro Healing. All the other plaintiffs, they are also moot because, as we indicated in our notice filed a week or two ago, all of the other counties have been filled, so there are no more certificates available for allocation. And my time is out. Thank you.
Counsel, before you start,
Okay.
let me,
Then pause the clock. I'm kidding.
No.
I'm kidding.
no. I come back to this 2803A4A, which says that the department has rulemaking power as to the manner in which applications are reviewed. How can you differentiate any kind of, meaningfully, any kind of temporal wall between the when and the how? How does manner not encompass both of those in any kind of workable situation, any kind of workable interpretation of the rule?
My argument is that manner does mean the when. However, the limitation under 4A is that it has to protect against diversion and theft. And the applications currently do, because they ask for a security plan, they ask for inventory, and that's how they're determining the manner in which they consider the applications for diversion and theft, is that they're looking at the security procedures in the application, and that has to be part of the application.
And so an annual process, an annual review process is not in any way, shape, or form related to guarding against, say, like insider trading arrangements where someone can just, say, hey, I'm about to exit the market, you get into the market,
Well,
and
so
file the next day so that you have priority?
Number one, no. That's not what it's looking to prevent. And two, this court has affirmed a case in which that exactly happened. There, in the 2016 allocation, a dispensary moved, but before they moved, the same owners applied for an application at that location before they moved, and then when they submitted the application, they moved to another county, and another applicant had filed and said, well, I meet all the requirements, and so you shouldn't consider that because they moved, but the court said, no, that's valid because the original location still has the most dense population around it. And so the court affirmed that type of behavior already. I know my time is out. I want to give you a few cites for
Very quickly, Counsel.
Yeah, Doc 42, page 1 through 2, Doc 42 at page 8. Those are the answering brief of the MSJ, and then also Doc 34, page 11 through 12, discusses the authority for the department to adopt rules. I had other points, but I guess I will not address those.
Thank you, Counsel.
Can I make one?
I'm not going to give you any more time. Thank you. All right, thank you, folks. We appreciate the argument and your folks being very well prepared for it here today and being focused on our questions. We're going to take the matter under advisement. We will issue our ruling in due course, and the court is adjourned. I will leave